welcome everyone to this masterclass. It's fair for me to say that ACEN, the role of ACEN, in so many ways is to facilitate its members, to allow us to do our business in the best possible way, to become not just world-class, but to ensure we're making use of best practice. And I'm extremely proud of a lot of the various accomplishments of our members, but we must not rest on our oars at all. And so that's why this World Bank sponsored training has become a very major part of ACEN, and it will continue to do so. Now we are very lucky. For those who are not able to be at the full training, we actually have a masterclass very generously donated by Mr. Husni Madhi, and we really thank you for this. I will warn you that these days, any webinar that's not free, these days, people seem to run away. I think no one can remember again when they ever paid for it. But for something of this magnitude, we are really thankful for it, and we look forward to it. So please, at this stage, I will announce the webinar open, and please hand over to our most valued facilitator. And I hope we will all give him a welcoming round of electronic applause, please. Thank you so much.
Thank you, President Conley. Thank you so much for the kind words and for the warm welcome, and of course for this kind invitation to contribute to the ACEN World Bank program, and of course to deliver this masterclass. It's my pleasure to deliver this, of course, free of charge to our colleagues in Nigeria, to spread knowledge and know-how among our colleagues with regards to contract administration and FIDIC conditions of contract in general. So I feel it is a duty more than anything else towards my colleagues and friends here in Nigeria. So for those of you who don't know me, I'm Husni Madhi. I'm a civil engineer, and I have a master's in law, LLM, in construction law and arbitration. I'm primarily an international arbitrator, adjudicator, dispute board member, and mediator. I'm a member of the FIDIC Contracts Committee. The FIDIC Contracts Committee is the committee which drafts all of the FIDIC contracts and forms of agreements. I'm a FIDIC certified FIDIC certified adjudicator, and I'm listed on the FIDIC's president's list of approved dispute adjudicators. I'm a FIDIC certified international trainer. I'm the chairman of Task Group 15, Task Group 15B, in charge of establishing the FIDIC's golden principles. I'm also the sole and official translator of FIDIC 2017 and the White Book 2017 into Arabic, mandated by FIDIC. Also, I'm the Jordan country representative of DRBF, Dispute Resolution Board Foundation, based in USA, which is only concerned with dispute boards. And also, I'm a fellow of the Chartered Institute of Arbitrators in the UK. I'm an accredited mediator by CIR, Chartered Institute of Arbitrators, and FIDIC. And also, I'm also a fellow of the Arbitrators and Mediators of New Zealand, FAMENS, in addition to so many memberships in my home country in Jordan. I'm based in Jordan, but my work is international, Africa, Europe, and Asia. This is, in a nutshell, a quick background about me as a lecturer for today's masterclass. I will try to make this masterclass as interactive as possible, so I will deliver a quick academic lecture, 30 minutes, 45 minutes max, and then I will open the floor for questions, whether for our colleagues online or our colleagues attending in person, whom I'd like also to thank after having a long working day, you're tired, but still you are interested in learning more and attending this masterclass. And those also online, also after a long day, I really thank you and congratulate you for attending such a masterclass. My main focus today will be on contract administration in general, and specifically on FIDIC conditions of contract. So, because I believe this is an important subject, yesterday and today, and we will continue tomorrow and the day after, we have, as President Conley said, we have the ACEN World Bank training. And one of our colleagues during the training said that there is around 54,000 projects currently being undertaken in Nigeria. So the matter of contract administration and regulating the contracts for these tens of thousands of projects in such a huge country as Nigeria is not an easy task. So it is very imperative that we understand what is contract administration is all about and what are the famous contracts or forms of contracts in general that we have in the industry or worldwide. So let me start first by why FIDIC and why standard forms of contract. But before I do that, let me give you just a quick overview about FIDIC as a federation. FIDIC is an acronym which stands for the French words Fédération Internationale des Ingénieurs-Conseils, the International Federation of Consulting Engineers. So the substance of this federation is consulting engineering and consulting engineers. And it was established back in 1913, 113 years ago, by the National Associations of Consulting Engineers from Belgium, France, and Switzerland. And these countries are either partly or wholly Francophone. They speak French, and this explains the French name and the French acronym of the federation. Of course, today, the official language at FIDIC is the English language. All of our publications are initially published in English and then afterwards translated into other languages. Now, the founding principles of FIDIC as a federation were and still are 113 years after its establishment are three: quality, integrity, and sustainability. Now, all of FIDIC's actions, conferences, webinars, trainings, publications, all stem from and revolve around these three founding principles. So unlike what many people may think, FIDIC not only publishes forms of contract, we publish a lot of guides which cater to the consulting engineering industry, like the quality-based selection, or now what is called the cost and quality-based selection, a guide published to help employers how to select consultants based on quality. Other guidelines, which is called the quality of construction. Other guideline called consultancy services, which will help us articulate the scope of a consultant. We have so many guidelines, such as FIMS, FIDIC Integrity Management System. And also we have guidelines with regards to sustainability, with regards to risk management, and so on and so forth. And FIDIC offers these guides free of charge in PDF downloadable format from FIDIC's website, fidic.org. So many people think that we only publish forms of contract, which is completely incorrect. We publish a wide array of guidelines and publications of good practice and so on and so forth to spread knowledge and know-how. And many of these are offered free of charge. You can visit fidic.org. We have a bookshop on fidic.org where you can download these guidelines free of charge. Of course, we at FIDIC are very famous for our construction contracts. The FIDIC, primarily the FIDIC Red Book, the FIDIC Conditions of Contract for Construction. Now, the committee responsible for the drafting of all of the contracts and all of the agreements is called the Contracts Committee, the CC. and I have the honor of being a member on the Contracts Committee since 2019. So any contract that was published or will be published, or a form of agreement or services agreement that has been published or will be published by FIDIC, it is the result of the work of the Contracts Committee. And also, we publish guides to explain how to use these forms of contract and how to use these agreements or services agreements. Now, this begs the question, why FIDIC contracts? And FIDIC contracts are considered standard forms of contract. What is the opposite of that? The opposite of that is called bespoke contracts. Bespoke contracts is the contract, which is 2, 3, 5, 10 pages, drafted by a lawyer for a specific project. So why should we go for FIDIC? And by extension, we're going for a standard form of contract rather than going for a bespoke form of contract. Now, standard forms have huge advantages over bespoke contracts. And I can name a few without limitation. Now, standard forms of contract save a lot of time and effort and cost in drafting work. Now, if you look at the general conditions, the Red Book 2017, it's 248 pages between the general conditions of the contract itself and guidance for the preparation of particular conditions. So the contract and some guidance provided by FIDIC. You will never ever see a bespoke contract that is detailed as such, 248 pages. And it saves a lot of drafting work because, as we all know, in standard forms of contract, specifically FIDIC publishes what is called general conditions. General conditions which are applicable almost everywhere, almost all of the time. However, this is ready-made for you by FIDIC itself. However, the employer will have to prepare particular conditions. The employer will have to prepare particular conditions to reflect the specificities of the project, the local requirements, his own requirements, I mean the employer's requirements, and in order to comply with the applicable law. So yes, we have the main structure, which is the general conditions, and we need to do minor work through the particular conditions, as I said, to reflect the locality of the project, the specificity of the project, and my own specific requirements as an employer. So I don't start from scratch. Secondly, and of course, this will save a lot of time in drafting work and by extension, a lot of cost. Secondly, it is crafted with care. I mean, the standard forms of contract are crafted with care. It took us a lot of years. For example, the FIDIC 1999, it was drafted between 1994 and 1998. And in 1998, we released a test edition for the industry to test so that we collect feedback. And it was released officially back in 1999. And at FIDIC, our standard forms of contract, we built on previous editions. So once the 1999 edition was released, we continued using it throughout the years. And the second edition was published back in 2017. So you're talking about an international federation putting a lot of effort in drafting these standard forms of contract and collecting feedback from all over the world through all jurisdictions around the world in order to better these editions into the next edition. And not only it takes a lot of years to draft an edition of a standard FIDIC standard form of contract, it requires a lot of specialists, and we depend on volunteers. All of the Contracts Committee members, all 10 of them, we are all volunteers, and all of our task group members are all volunteers, and our friendly reviewers are all volunteers. We want to contribute and give back to the industry, and we do it free of charge. But we have a wide array of experiences in any task group entrusted with drafting a new standard form or updating an existing standard form. We have engineers. We have engineers with legal qualifications. We have engineers with site experience from the contractor side, from the employer side, from the engineers or consultants side. We have also people with experiences with multilateral development banks and financiers. We have lawyers with us. And after we finish, we have our special advisors who are, who possess long experience, distinguished experience in dealing with contracts. And we have legal review for our contracts. And then finally, we have the friendly reviewers. We have like the inner circle of FIDIC. We release initially, give copies of advanced drafts of these forms of contract to our friendly reviewers to give us a feedback. So as you can see, we are not under the rush of urgent projects or imminent projects like the bespoke contracts. The bespoke contract, they will go to the lawyer, listen, we want this contract yesterday. So they are under the rush of urgency, under the constraint of time. So they will never take, for example, 4 years or 5 years to prepare a contract. Maximum is going to be 1 month. So with standard forms of contract being, we have taken the time, we have aggregated a huge pool of experiences in drafting it, and we collect feedback from all over the world. No lawyer or engineer can compete with that when they are preparing bespoke contracts. Now, as I said, because the standard forms of contract remain there for a long period of time and they are tested throughout the editions, they are stable. And the possibility of having issues with the drafting is very minimal compared to bespoke contracts. So because we have tested this through the first edition, second edition, we gained feedback from all over the world. We took our time, we gained a lot of experience and feedback, and also comments from the friendly reviewers and the special advisors and so on and so forth. So it's more stable than any bespoke contract. And of course, it provides a common ground for understanding. Now, bespoke contracts are dealt with huge skepticism by contractors. They don't know that contract. They have to read it thoroughly because this is the first time they see this bespoke contracts. But with standard forms of contracts, we are used to it. Give me a FIDIC contract and throw me in any country in the world. Send me to the South Pole. It doesn't matter. It's a FIDIC contract. So contractors will be tempted more to tender for these international forms of contract. And this is a recommendation for our colleagues in Nigeria. If you want international contracts, which are not, for example, World Bank financed or multilateral development banks like the African Development Bank, adopt FIDIC standard forms of contracts because they are known by virtually every person in the industry. But if you use a standard local form or a bespoke contract, the contractors will be a bit apprehensive. And they will put a huge risk contingency in their price because they don't know the ins and outs of that contract, even if they read it, but they have never tested it before. So definitely they will put a risk contingency, an amount of money in their tender price to cater for any contractual risks, which is a money that is unnecessarily will be paid later on by the employer, given the alternative, because FIDIC standard forms of contract have been for so many years, for so many decades in the industry, that international contractors know by heart and have no problem going to any country to construct these projects. Now, our first standard form of contract that was published by FIDIC was published back in 1957. 1957, which is 69 years ago. We have under our belts at FIDIC 69 years of experience in international contracts and standard forms of contracts. So this is why standard forms of contract in general, and specifically FIDIC, because it's an international form of contract, has an advantage over any other bespoke contract. And also we have another advantage. The first edition that was published by FIDIC back in 1957 was the first international form of construction contract in mankind history. So it was the first time in history that we have an international form of contract. So we all have domestic forms of contract. Virtually every country has its own domestic form of contract, but we, FIDIC, we were the first to draft and publish the first international construction form of contract. Now, why it took us from 1913 to 1957 to issue our first form of contract? Okay, sorry, use this mic, sorry. Thank you. So let me use this mic for our colleagues here. Just a second, okay. Sorry for the interruption. So many people might ask why it took you so many years from 1913 to 1957 to publish the first edition and the first international form of contract. Actually, in 1913, we established FIDIC, 1914 to 1918, First World War, okay? Then the world barely took breath, only to find itself entering into World War II, 1939 to 1945. Okay, sorry. Okay. 1945, World War II ended. Now, as many of you know, after World War II, many countries of Europe were basically destroyed. And those of you who know history, we know about the Marshall Plan, American Marshall Plan, to rebuild Europe. So this meant that contractors from one country went to other countries to construct these projects and in the reconstruction effort to reconstruct Europe. So people from even one legal system going to a country that adopts a completely different legal system. So the expectations, whether from the contractor and the employer, were different. The legal culture, so maybe a contractor coming from a common law country like Nigeria. Nigeria is a common law country. Going to a country such as Germany, which is a civil law country. So the legal culture is different. And also each country had its own domestic form of construction contract, which is not the same between one country to other. So the expectations, the legal culture, and the contractual background, and even the way how things are done are different between the contractor and the employer in these international contracts, which created a demand for an international form of contract. And in an answer to that, FIDIC published the first international form of construction contract back in 1957. Now, this form in 1957 was dedicated to civil works and building works, so building and civil engineering works. And it happens that the color of the cover of that book is red. So people started saying, could you please hand me over that red book? What red book? Give me that red book. So it became a norm in the industry, which is unofficial, to refer to FIDIC books by its color. Now, we didn't embrace this officially. However, we embrace it for training, conferences, lectures, and so on and so forth. We unofficially refer to the books by their color. However, contractually speaking and legally, we need to refer to that specific contract by its official name. For example, the Red Book, Conditions of Contract for Construction. This is its official name. Now, second edition 1969, third edition 1977, fourth edition 1987, and it was the most widely used Red Book pre-1999. It is still used in many parts around the world, and also USAID still uses the 1987 fourth edition Red Book with amendments, of course, heavy amendments. Now, in 1963, FIDIC published its first form of contract for electrical and mechanical works, electromechanical works. So, 1963, first edition of the electromechanical works, second edition 1980, third edition 1987, which was the most widely used daily book pre-1999. In 1995, FIDIC published its first and only edition of the Orange Book, design, build, and turnkey form of contract, in an answer to a demand in markets such as USA, because they prefer such an arrangement. Now, in the Orange Book, FIDIC achieved huge developments in terms of form, format, and content, to the extent that it encouraged FIDIC to adopt these new achievements in the Orange Book to update the old forms of contract, to result in what we now know the 1999 suite, or also known as the Rainbow Suite. Okay? Now, after that, FIDIC published the Gold Book in 2008, Design, Build, and Operate. And afterwards, it published the 2017 suite, which is the second edition of the 1999 first edition. Now, the major difference, now you're wondering, why 1999 first edition and we ended the Red Book in 1987 at fourth edition? Because the whole concept of how to select a contract has completely changed. Before 1999, the nature of the works involved in the project dictated the type of the contract. So civil works, civil engineering, civil works, building works, Red Book, electrical works, Yellow Book, design, build, turnkey, Orange Book. Now, this concept has been completely changed from 1999 onwards. Now, we don't care what is the type of the works entailed in the project. Rather, what matters to us and the most pivotal criterion that decides which book to use is who is responsible for the design as between the employer and the contractor. So if it is the employer that is responsible for the design, we use the Red Book. It's called Conditions of Contract for Construction. So the contractor is only required to do construction, no design. Since we have only two parties to a contract, employer and contractor, and the design is not the contractor's risk, then whose risk it is? It is the employer's risk. Under the Yellow Book, if the design is the contractor's design, then we use the Yellow Book. We no longer care whether it is civil works, electrical works, or whatever nature of the work. As long as it is designed by the contractor, we go to the Yellow Book. The Silver Book is an EPC turnkey contract where the design is also done by the contractor. However, this is a turnkey solution. The contractor is responsible for everything from A to Z to hand over a project to the employer ready to be used at the turn of a key. Design, build, and operate, the Gold Book. The Gold Book 2008, DBO, design, build, and operate. The contractor is required to design the works, build the works, and he is also responsible, the contractor, for long periods of technical operation. So I'm not responsible for commercial operation as a contractor. So the other day we gave the example of this hotel. As a contractor, if I'm to be contracted on a Gold Book basis for this hotel, I'm responsible for its design, I'm responsible for its building, construction, and I'm responsible for its technical operation for the coming 20 years. Technical operation, meaning that I want to make sure that every single system is up and running. But I'm, as a contractor, not responsible for the check-in, check-out. The chef is good, the chef is bad. I'm not, this commercial front desk operation is not within my scope. I'm only responsible for the technical operation. I need to make sure that all of the electrical systems are up and running, the elevators are up and running, hot, cold water, HVA system. You won't even see my people. My people are in overhauls doing, preventive maintenance and corrective maintenance all over the building. So this is, in a nutshell, the major books that we have in FIDIC, and the 2017 suite was the second edition of the Red, Yellow, and Silver. Okay. Another book was contained in the Rainbow Suite in 1999, but not in the 2017 suite, is the Green Book. The Green Book is the short form of contract for simple works, straightforward works, simple repetitive work. We issued the second edition of the Green Book in 2021, not with the 2017 suite, so it's now separated from the Rainbow Suite, so to speak. Now, FIDIC conditions of contract adopt the fair and balanced risk-reward allocation. What does that mean? So we always adopt, So we always adopt a fair and balanced risk-reward allocation, meaning if we put the employer's risk in the one hand and the contractor's risk in the other hand, we have a balance, and the allocation between these two is fair between the contractor and the employer. And the risk stems from three major sources: fluctuation of quantities, going above or below what is mentioned in the BOQ, and quantities will translate into money. And we have the conventional cost risk, and we have time risks. The time for completion will be delayed, or there is an extension of time, and time is money. So it all boils down to money. How we deal with risks, we deal with risks through money. And we have adopted the fair and balanced risk-reward allocation throughout the history of FIDIC. Now, under the Silver Book, there is a huge risk allocation towards the contractor. So the risk allocation is like this. And many people criticize FIDIC. You say fair and balanced risk allocation between the employer and the contractor. And the Silver Book, it's like this. This is why in the golden principles, FIDIC golden principles, and I will come to explain them now shortly, we have changed this to become fair and balanced risk-reward allocation. Why? Because yes, the risk allocation is like this under the Silver Book, but we have instituted and reinstated balance in the contract by paying the contractor extra. Because there's nothing free in this world. In exchange of these risks which are allocated to the contractor, we pay the contractor an extra amount. So we reinstated balance in the contract. And this is why now in the FIDIC golden principles, we say fair and balanced risk-reward allocation. Speaking of the golden principles, FIDIC golden principles. Now, after 2008, the global financial crisis, we are living in what is called an employer's market, meaning that I'm an employer, I tender a project, I'm expecting 10 tenders to apply, I receive 30 tenders because of the bad global economic situation. And no matter what harsh conditions I introduce in the particular conditions, contractors will come and submit their tenders and accept to enter into a contract with me. Now, this tempted employers with time to significantly alter the fair and balanced risk-reward allocation in FIDIC's general conditions, to the extent that contracts are becoming FIDIC contracts only by name. The only relationship between these contracts and FIDIC is that on the cover of the particular conditions, it says that this is a FIDIC contract. Once you open the particular conditions, you'd see that the general conditions were butchered and mutilated beyond recognition. Now, as I said, employers like to promote their contracts as being FIDIC contracts because, as I said, FIDIC contracts are known around the world, and this will, promote the contract and attract more international contractors because we all know FIDIC contracts. But when they open the particular conditions, they see that our fair and balanced risk-reward allocation principles, which have proved to be successful over the past 69 years, are mutilated beyond recognition. This is misleading to the public and unfair to contractors and injurious to our FIDIC trademark fair and balanced risk-reward allocation contracts, our fair and balanced contracts. In conferences and master classes like these and lectures, we were always asked by participants, why don't you sue such employers? As a federation, FIDIC cannot go after the whole world and sue them. And there's a principle under the law, it's called freedom of contract, okay? If they did not breach the copyright of the general conditions, I cannot take any action against anyone. And if I can, as a federation, we're not interested to go after the whole world. We can't. So back in 2016, I made a recommendation saying that most of these misuses of the contract stem from a lack of proper understanding of the contracts of the employers. Because if they knew that with these changes they are actually shooting themselves in the foot, they wouldn't have done it in the first place. And based on this recommendation, I was appointed the chair of Task Group 15 to establish the Golden Principles. Now, the Golden Principles are drafted in, and actually, what is the purpose of Golden Principles? The very purpose of the Golden Principles is to provide guidance for the industry, how to draft particular conditions, so that our contract is truly before the particular conditions and after the particular conditions is in fact and truly a FIDIC contract. So these are the basic principles that need to be adhered to. Now, we tried to draft the principles in a principles format, general principles, to promote better understanding and to be easily used around the world in every single jurisdiction, no matter what this jurisdiction may be. Because at the end of the day, FIDIC is an international federation which issues international forms of contract. So we're not catering to a certain specific jurisdiction. So when you write it in a general principle format, it's applicable anywhere, all of the time. And we try to limit the number to the lowest number possible, which is 5. We have 5 golden principles. And each golden principle relates to a single principle that is readily understood. Now, I made a recommendation to FIDIC that if you want to promote better understanding of how to prepare the particular conditions and the golden principles, you have to offer them free of charge to the users. So now, if you go to FIDIC.org, FIDIC's website, you can download the golden principles free of charge, okay? So you can go to FIDIC.org and download. It's a small guide, not a huge guide, but it's a very valuable and important guide. Now, in every single conference, they are talked about. All of the multilateral development banks, the World Bank, the African Development Bank, the Islamic Development Bank, are all talking about the golden principles and asking for adherence with these golden principles when employers are preparing their particular conditions. Now, I'll go briefly through the golden principles. Golden principle number 1 relates to roles and responsibilities. It says that roles, responsibilities, and obligations of the contract participants. Contract participants is a term coined by the golden principles. Under PMI, we have major stakeholders. And also on the other part, we have the 2 parties. Every contract has only 2 parties, the employer and the contractor. Contract participants are the 2 parties plus the major stakeholders, okay? So the roles, responsibilities, and obligations of the contract participants, meaning the 2 parties plus the engineer, plus the subcontractors, plus the dispute board member, and so on and so forth, shall not be altered significantly from those mentioned in the general conditions. So for example, under the Red Book, this fair and balanced risk-reward allocation between the employer and the contractor hinges on a pivotal role to be played by the engineer as a contract administrator and supervisor and certifier between the employer and the contractor. If you significantly change the engineer's role, you are distorting that balance achieved by FIDIC in the general conditions. Golden principle number 2, it relates to clarity of drafting of the particular conditions. So the particular conditions should be drafted clearly and unambiguously. And this is not something new. Actually, you might say it doesn't need a rocket scientist to know this. Everybody knows this. It was mentioned in FIDIC 1999 in the forward and part 2 of 1999. Yes, I agree with you. This is a very simple principle to understand. But I work as an international arbitration, and I don't want to give you any percentages, but you cannot imagine how many disputes we deal with on a daily basis, the cause of which is unclear and ambiguous particular conditions. So always make sure, yes, this is an easy principle to understand, but it appears to be a very difficult principle to apply in reality and in practical life in projects. Golden principle number 3 relates to risk allocation. Now, the risk allocation envisioned by the general conditions should not be significantly or altered in the particular conditions. And the risk allocation in the general conditions adopted by FIDIC is not haphazard. It's based on scientific basis. The risk allocation is based on Abrahamson principles as defined by Dr. Nael Bunni. Max Abrahamson, back in 1983, wrote a very important paper on construction risks. In 2009, Dr. Nael Bunni, in also another important paper, refined these principles into 4 simple questions. We subject each risk to these 4 simple questions on a risk-by-risk basis, and the answer will lead us to the best party that is capable of being allocated that risk as between the employer and the contractor. So the first question, as between the employer and the contractor, who is best able to foresee and anticipate the risk and forecast the risk? Second one, who is best of these 2 parties to control the risk from eventuating, and even if it eventuates, controls the negative impact of the risk? Question number 3, who can best bear the negative consequences of a risk? What happens to a party which is unable to bear the negative consequences of a risk? We said we deal with risks through an amount of money, risk contingency. So if the risk requires financial capabilities here and that party's financial capabilities are here, what will happen to that party? She will go bankrupt. So we're not in the business of bankrupting people. This is number 1. Secondly, and most importantly, if you were able to get a compensation of $1, if that party is bankrupt, you'll get 0. You'll get nothing. And the final question, which of the 2 parties benefits more or suffers more if the risk eventuates? The answer to these risks will lead us to the best as between the employer and the contractor to bear that risk. Of course, there is a risk allocation under the law, high-level risk allocation stipulated by the law, and then we have a gap-filling, fully detailed risk allocation in the general conditions, and afterwards, any risk that remains unallocated between the employer and the contractor, or you want to reallocate certain risks, you can do so through the particular conditions following these principles. One good example of GP3, breach of GP3, and this is something I face, for example, in UAE or KSA in the Gulf countries. The Red Book, the design responsibility rests with the employer. This is how the FIDIC Red Book is based. The FIDIC Red Book is based on a principle that the design is the employer's responsibility. I see this quite often in the particular conditions, is that the contractor has a contractual obligation to perform a design review and he's responsible for correcting any errors in the design. Now, this causes a lot of problems. First of all, design review costs around 85 to 90% of the original design. So, Mr. Employer, you have basically paid the cost of the design nearly twice. Secondly, design liability. If you ask the contractor to amend on the original design, then it becomes, the design is mixed between the original designer work and the contractor's designer work. Who's responsible in the eyes of the law? Okay, so there's a liability under the law. Thirdly, we don't have detailed mechanisms under the Red Book to deal with detailed design by the contractor. So if you want to shift the design risk to the contractor, use the Yellow Book or the Silver Book, not the Red Book. Golden principle number 4 relates to time. Now, time durations under the general conditions are 2 types. Those which the general conditions permit you to amend by saying unless otherwise stated in the particular conditions. For example, the time for payment of the interim payment certificates to the contractor, 56 days, unless otherwise stated in the particular conditions. And other durations which you are not permitted to amend by the general conditions. For example, the time to give a notice of claim, 28 days, period, full stop, no room for amendment. Now, GP4 says that for those durations which the general conditions allow you to amend, the resultant amended duration should not be too long or too short for a contract participant not to be able to perform any of its contractual obligations. And finally, GP5 is that disputes must be first referred to dispute boards, 1999 Dispute Adjudication Board, or Dispute Avoidance and Adjudication Board in 2017 as a condition precedent before going to arbitration. Okay, we have adopted dispute boards since 1999. Actually, in 1996, we have issued an annex to the FIDIC 1987 4th edition because the World Bank adopted dispute boards. So we issued that annex in 1996. That works as a plugin on the 1987 4th edition. And now, 1999 onwards, all of our contracts has dispute boards embedded into them. These are the 5 golden principles. Now, you remember I said that if employers knew with these amendments that they are shooting themselves in the foot, they wouldn't have done these significant amendments to the FIDIC general conditions. Now, let's go back, for example, the design review risk. Now, risks need, if they are the employer risk, there are 3 conditions to be satisfied to pay to the contractor. The risk must eventuate, and the contractor, as a consequence of the occurrence of the risk, must incur damages, and we compensate the contractor for his actual damages. But if you shift risks unnecessarily to the contractor will put a price for it, risk contingency, and embed it into his price. It's not a BOQ item. It's spread over his prices over the BOQ, the bill of quantity. So you will be paying for that risk, whether it eventuates or not. Once you shifted unnecessarily, you shifted that risk to the contractor, you'll be paying for this risk, whether it eventuates or not. It's already embedded in his price. And you'll pay to the contractor whether he incurred damages or not. And God only knows for what you will be paying. You certainly will not be paying for the actual contractor's actual damages. We have the Monte Carlo equation, best case scenario, worst case scenario, and the contractors will put buffers on top of the risk contingency that is already buffered that they will include in their prices. And on top of it, they will put overheads and profit. So it is not wise to shift risks unnecessarily to the contractor. Because let's put cost aside. If we significantly distort the risk allocation of the general conditions, like in the Red Book, the design is the employer risk, we shift the design risk to the contractor under a Red Book, okay, which is seriously wrong. Now, the qualified professional contractors during the tender stage will refrain from submitting any tender. This is, a wrinkled contract. It doesn't work. A Red Book. As a contractor, me designing, this will, end up with issues. So first consequence, qualified contractors will identify this immediately and they will refrain from submitting their tender. So the employer will end up with 2 types of contractors. Those which are unqualified and were unable to identify that there are serious amendments and that will cause problems in the Red Book, or gambler contractors. Okay, they play Russian roulette. Let's submit and see what happens. And believe me, as an employer, you don't want to end up with either of these 2 contractors. So if you end up with these 2, then contractors, 2 types of contractors, you will have to award the contract to someone who is unqualified or a gambler, because all qualified contractors refrain from submitting their tender. And once they start work, and these risks start to eventuate, and these risks were not taken into consideration in their price and in their time program, so they will get delayed, and they will have rejected works, causing rework, causing extra cost, causing extra delays, which will worsen the situation, and the contractor will be stuck in this quicksand, okay? One attracts the other. Rework attracts additional cost. Additional cost will reflect negatively on the contractor's progress. We are in a delay. Delay situation will reflect negatively on the work, and so on and so forth. So the contractor now will start looking for a way out. And what is the first thing that will come to the mind of the contractor? Submit claims, open the floodgates of claims. We have entitlement. We don't have an entitlement. We don't care. We throw the seeds and hopefully we will get something. And when contractors start doing this, employers and their consultants, the engineer, the FIDIC engineer, will start noticing that this is, this is an unprofessional contractor. He's playing around, submitting these unmerited claims, and the relationship between the employer and the contractor will start deteriorating. The contractor would say, this is a crook employer. I know the red book, but the design has never been the contractor's responsibility. The employer would say that this is a crook contractor. They are submitting the claims here and there without any merit. This will result into disputes, and ultimately this may lead to a termination of the contract. And who is the biggest loser in case the contract is delayed or terminated? It is the employer. See, Mr. Employer, that you shot yourself in the foot the moment you shifted risks unnecessarily to the contractor. So today, compared today, now we are in a termination. When you were drafting the particular conditions like 3 years, 4 years, 5 years ago, now you realized, I've shot myself in the foot by unnecessarily and unreasonably and unfairly shifting risks toward the contractor. So the understanding of these principles is imperative. Knowing that such things exist in the industry, FIDIC conditions of contract, the principles upon which these FIDIC conditions of contract are based, the golden principles, the principles of risk allocation. Risk allocation is really important. The first thing in any contractual case you are faced, the first question you should ask yourself, whose risk is that? And we have only two parties to blame, either the employer or the contractor, because we only have two parties. I get this comment quite often. Why did you shift this risk to the employer or the contractor? Well, we have two parties. It's either the contractor or the employer. No, it's not fair. Neither the employer nor the contractor should be allocated this risk. Then to whom? We only have two parties. Either it's the employer or the contractor. Yes, I understand. Sometimes it's not ideal to allocate it to one of them, but the reality of things, we have two parties to a contract. One of them should carry that risk. If it's not the employer, it's the contractor. If it's not the contractor, it's the employer. So these are the general principles that I wanted to share with you the history of the FIDIC as a federation, the history of our contracts, the advantages of our contracts, the principles upon which our contracts are based, the golden principles, the risk allocation, and the advantages, and the appeal to international investment, and the attraction factor that FIDIC conditions of contract will provide to international contractors. You bring them over to Nigeria to work on projects, in international projects. You bring international experience. We also learn from the international people who come, irrespective from where they come, because international experience is by far better than any local experience, no matter what is that local experience. So I would like to thank you again. I would like to thank ACEN again for this opportunity to speak to my friends and colleagues from Nigeria and the members of ACEN. My relationship with ACEN goes back to 8 years ago. I started delivering training with ACEN since 2019. This is my 6th time in Nigeria, 3 in Lagos and 3 in Abuja. So I find this a great opportunity to share some knowledge with my friends and colleagues in Nigeria. So I'll open the floor now. I want this masterclass to be interactive as possible. So you can ask any question you may wish, whether according to what I have explained or not. I see that Engineer Sharafuddin is raising his hand. Please, Engineer Sharafuddin, go ahead with your question if you have a question. If you want, you can open the mic and the cam, or you can type it in the chat box.
Okay, thank you, erudite presenter. Your presentation is well understood. But my worry is the last part of the statement you made as per the sharing of responsible risk between contractor and the client, I mean the promoter. I want to also believe that there are some conditions which both the contractors and the client have to share the risk. In the case of force majeure, natural occurrences that is neither the fault of the contractor, neither that of the client, how would that particular risk be shifted on one of the parties? For example, a project that is affected by natural disasters, and perhaps the extent of damage is seen as something that it's maybe too huge for either the contractor or the client. Is there no case that the risk will be shared between both the contractor and the client?
Okay, so you refer to a situation which falls under force majeure, and in 2017 contracts, we now call it exceptional events, and you specifically refer to natural disasters or actions of forces of nature. Now, these are called acts of God. Throughout all legal systems, they are called acts of God. And as you said, this is not a fault of the employer, not the fault of the contractor. In acts of God, and this is regulated under FIDIC conditions of contract, force majeure in FIDIC 1999 is clause 19, and exceptional events, we've changed the name from force majeure to exceptional events, is regulated under clause 18 in the 2017 second editions. Now, specifically talking about natural catastrophes, acts of God, the loss is shared between the employer and the contractor, meaning the contractor is entitled to an extension of time. So as an employer, I'm bearing my share of the damages by accepting the project to be delayed, and I'm giving you an extension of time as a shield against the delay damages. So I have accepted and taken the loss of accepting my project being delayed, and I'm granting you an extension of time, and I'm no longer able to apply delay damages. On the other side, the contractor will absorb all of his financial losses. So yes, the project is extended, but all of the contractor's financial losses, whether direct losses as a consequence of the natural catastrophe, maybe we had a flood and the flood damaged his equipment, or the prolongation cost, the cost of the extension of time. So the contractor cannot claim for prolongation cost or for any additional cost as a direct consequence of the force majeure. So the contractor is accepting to bear the share of the cost claim attached to that extension of time. Of course, the insurance will cover part of the contractor's damages, any damages as a consequence of natural catastrophes of his equipment, but other damages are not covered by the insurance. Of course, there are other force majeure instances or exceptional events where the employer will compensate the contractor, but we compensate the contractor only for his direct costs and indirect costs with no profit. Also, this is a risk sharing. Of course, in cases of war, whether declared or not, anywhere in the world, if you establish that that war affected you, for example, you were importing paint or petrochemicals from Gulf states, and now the Strait of Hormuz is closed. This is a force majeure, an exceptional event. You're unable to deliver the paint. So cost can be claimed in case of war. Other situations mentioned in subclause 19.4, 1999, or 18.4, 2017 include riot, unrest, political unrest, and so on and so forth. They need to occur in the country. There is a definition of country in FIDIC conditions of contract. So all of these matters are handled and allocated within the FIDIC general conditions, whether it's force majeure or other matters. So if you read the general conditions, we have catered to virtually every thing, including the force majeure and exceptional events. Do we have a question from the floor here in the face-to-face? Okay.
Yeah.
Yes, yes.
I looked at the EPC
Mm-hmm.
and the risk allocation, as you said, is the same. The risk allocation.
Yeah, of course, there is a risk in every contract. There is a risk allocation, but it's different from the red and different from the yellow books.
Okay, but the EPC is not the red, I think.
The EPC is under the silver book.
Silver
book, yeah.
So, which of the risk allocation do we have in the risk in the silver book? Is it extension of time, and the contractor will take over? Because the EPC is, I think, the contractor is to design the project and
yes,
construct and
yes,
it's something like a turnkey project.
Yes.
So the risk allocation there, is it an extension of time or both, or it's going to be maybe direct and indirect costs bearing by the client, or
we cannot generalize, but there is a subclause for extension of time. But the grounds, generally speaking, whether it is an extension of time or any other type of claim, the grounds upon which the contractor can claim under the silver book are very limited compared to the red and yellow. Let me give you an example. Exceptionally adverse climatic conditions is a ground for claiming an extension of time under the red and yellow, while we don't find it in the silver book. Unforeseeable physical conditions, subclause 4.12. It is an employer risk under the red and yellow. The contractor can claim for extension of time and cost capital C with no profit under subclause 4.12 in the red and yellow. But under the silver book, it is shifted towards the contractor. The contractor cannot claim for unforeseeable physical conditions. So it's not the American approach, turnkey approach, meaning zero employer risk, 100% contractor risk. This is the American approach. No, we have adopted a moderate approach with regards to EPC and turnkey contracts in FIDIC. So there is a huge risk allocation towards the contractor, but there remains a residual risk allocated to the employer. So there is some risk allocated to the employer. And this is why if you open the silver book, there is still an extension of time, subclause, variation clause, and claims clause. So it's not 100% contractor risk, zero employer risk under the silver book, no. But there is some residual risk remaining for the employer and a huge risk allocation towards the contractor.
And sorry, I want to understand the EPC. Will it be related to the PPP as a model of the PPP?
Now, under FIDIC, we don't select the contract based on the type of the project. Although we are currently at FIDIC's kitchen at the Contracts Committee, we are working on something related to the PPP. But the final picture is not clear yet. So maybe we may end up with guidelines on how to amend our general conditions, red, yellow, or silver, to be used in a PPP arrangement. But so far, we don't have a standard form issued by FIDIC dedicated to PPP because it's difficult. You know, PPP, it's a term, but the terms are not standard, okay? The concession agreement from the government to the investor is not the same. And it's different from one field to another. So PPP in photovoltaic power plants is different from offshore wind farms, from natural gas power plants, from wastewater treatment plants. It's different from one government to another, from one country. So you cannot generalize PPP. And don't take me on this. We still haven't finished. We've been researching this for years. Maybe it's been 6 years and since We started working on this. But most likely we will end up, and this is not sure, okay, this might be quite the opposite. Most likely we will not end up with a standard form for the reasons I have told you. Maybe we will issue a guideline, what to take into consideration in the particular conditions in our books in order to be used under a DPP arrangement. Okay, thank you. I have Engineer Okechukwu Charles. I hope I pronounced your name correctly. If not, I apologize. You have a question?
Yes, sir. Good evening, sir. I want to,
Good evening.
first of all, extend my deep appreciation to you for that wonderful lecture.
Thank you. Thank you. Thank you so much.
Very wonderful lecture, very extensive.
Thank you.
Having said that, I have one question. One, you know, I'm somebody that believes in arbitration, or call it alternative dispute resolution. And you dwelled a whole lot on arbitration. Some years back in Enugu State, a consultant who is a member of ACEN, I won't mention his name, he did some consultancy job for Enugu State, and he's been owed about 400 million then, more than 10 years ago.
Yeah.
I just give an example. In such scenario where you have been owed, especially by government, and over time you've been working for the government or an agency or an organization, is there a way that FIDIC or FIDIC in their contract agreement, that's in their template for signing contract, especially vis-a-vis consultancy, is there a clause that protects one? Or is there a better way of one getting his professional fees? Because most times they don't even use the standard scale of fees for costing. That's to determine what is your consultancy fee. In such scenario, because why I'm saying most times they don't use standard scale of fees is because jobs are not easily gotten. So the state government or the agency organization will say, we will pay you 7% of the total contract sum instead of 10% or 15%, as case may be. Is there a way of one getting his money without going through the litigation through the courts? Members of ACEN, like I'm a member of ACEN, is there a way that FIDIC protects them through arbitration, or is there a standard way of this? Okay, let me summarize the question by asking, most of our determining cost of consultancy, most times it is not what varies in Enugu State, for instance, may differ from what varies in Lagos State. Is there a way that FIDIC has a standard template for determining what becomes your consultancy fee?
Okay. We have a form of consultancy agreement or services agreement called the White Book. It is called Client Consultant Model Services Agreement. Now, if the client and consultant enter into a White Book, then the consultant's rights are protected through several layers. We made it very clear that there is a contractual obligation upon the client to pay the consultant's fees. If he doesn't do so, we can escalate this into a dispute. And there are, we have multi-tier dispute resolution clause under that White Book. And the same approach is adopted in all FIDIC conditions of contract. So we start with an amicable settlement, an attempt at an amicable settlement. If we don't agree, we don't, by the way, in all FIDIC contracts, we don't go to court. We go to arbitration ultimately. So if an amicable settlement fails, we go for adjudication. You have a sole adjudicator appointed, and his or her decision is binding on both parties, and there are mechanisms to enforce such a binding adjudicator's decision. Ultimately, if we are not satisfied or the adjudicator is not appointed, you can go to arbitration. And arbitration awards are final and binding. You can only set them aside for errors and anomalies in the procedure. I myself is an international arbitrator. I'm a strong advocate of all of the dispute resolution mechanisms, mediation, dispute boards, and ultimately arbitration, alternative dispute resolution, but never go to litigation because it takes a lot of you. So the protection that we are offering from FIDIC is that we're offering our white book, which provides this protection for both the client and the consultant, and we have this multi-tier dispute resolution mechanism.
Thank you, sir.
You're welcome. We have a question from the floor here, and we will come back to the online.
Question on trust.
Thank you, Mr. Madhi.
Thank you, Jibril.
I just want to make some clarifications. You know, we're dealing with FIDIC contracts, and we are talking about international standards. So I don't want us to confuse with local issues. Even though, you know, our brother is talking about Enugu State, and he's also talking about fees that they can charge. Maybe he's not aware that currently ACEN and COREN is the Council for Regulation of Engineering in Nigeria, are working together to finalize on the fees being charged. You know, what is called, they are actually professional fees that engineers will be charging, and the cut across is currently in progress, and coincidentally, I'm the chairman of that committee. But the clarification we also need to make here is, you came here as international expert to share with us the international best practice that we have all across the world. What is key is, what project do you have? What forms of contract? I mean, what type of contract do you think is going to be suitable for the situation that you have at hand, that you are going to use? Is what is the key takeaway for this our engagement?
Yes.
For example, you talk about the white book, you know, it's consultant.
Yes.
When you are talking about red book, the issue of who is designing and who is constructing. Then the other books. So the first and foremost is, let us understand which contract form are we, I mean, the type are we going to use from the books that we have. So sometimes the confusion here is, in our own local situation here, the agreements that you see with the agencies, they are a mixed bag. They are not actually particularly FIDIC alone. So these are the issues that we need to deal with locally. But let us first understand what you are presenting to us, to really understand the demarcations of these things. If we are taking of risks, which type of form are we going to use? Then if we are talking of a particular issue, where are the general conditions? What are our particular conditions? So we shouldn't mix up these things. I know it will sound somehow to you because you might not know the major issues that were actually affecting us here. But we also deal with those ones at ACEN. But thank you for the wider knowledge.
Thank you.
Thank you.
Thank you, Engineer Ibrahim, and thank you for informing me about that committee in place at ACEN and trying to somewhat put a standard for the consultant fees. So thank you for letting us know this and sharing this knowledge and giving us this local context within which we can explain the international experience and hope that some of it would be adopted in Nigeria. We have, yes, please. Yeah.
Already we have basically adopted most part of the FIDIC contract. We have what we call in that the BP, Real Public Procurement.
Yeah.
If you look at that document, basically we try to adopt most of FIDIC form of contracts. So in the forms. So all like he's talking about the fee, there are standard fees based on 1 month, that are charged both for consultancy services. We call it here the white book. We also have the consulting book. All this, we have the books in Nigeria, just like part of trying to, so that, like you said, to make it more international, bringing more experts, more contractors and consultants to participate in our contract in Nigeria. So there is a government agency that is both in states and the federal level. We have them, like he said, but you still have some little variation at the level of state government. Because if you take a typical World Bank procurement document today, not of the BPP, the differences are not much. So I just want to add this to.
Thank you.
What we do.
Thank you. But you need to promote this. You need the international contractors to know that your public procurement contract or law has borrowed a lot of the international features to make it attractive for international contractors to come, and also to reduce their prices so that they don't include risk contingency in their prices to cater to a contract which has borrowed some major elements from FIDIC, which is known to everybody. So you need to promote this internationally so that contractors coming understand this. And there are numerous ways. One of the ways, for example, books. There are certain books which explain how FIDIC is compliant or in conflict with local laws of certain countries. I have co-drafted 2 books in 2023 and one in 2025 dedicated solely to this. I drafted co-authored a chapter on Jordan explaining how the FIDIC general conditions conflict on some parts, in harmony with some parts, strict requirements to indicate certain matters in the particular conditions, recommendation to clarify further things things to take into consideration in the particular conditions. So all of this helps. So if I'm an international contractor or consultant coming to Nigeria, if there is such a book, and I'm sure there are numerous books, I will purchase that book and look for the chapter of Nigeria. If I'm going to Jordan, I will go to these books and purchase that book, because the one in 2023 we explained everything: the Engineers Association law, the contractors law, the tax law, the labor law, how in the FIDIC context, how the FIDIC contract is compliant or in contradiction with these laws. So this is one of the ways that you can try to promote your local law, that yes, it's local, but we have adopted a lot of international features, because this is what we did in Jordan. Our national form of contract is borrowed from FIDIC. It's heavily based on the FIDIC Red Book, and we have another one heavily based on the Green Book, and we're trying to promote this internationally to make it attractive for international contractors and consultants to come over and work in Jordan, for example, and the same applies to Nigeria. We have a question from Adewe Ajayi. So please forgive me if I mispronounce your names. The question is as follows. It's in the chat. Who bears the risk in a situation where a contractor imports equipment for a project and the ship got sinked in the high sea? What is the FIDIC view on this? FIDIC does not clearly deal with this, but we all know any shipment or any ship is used to deliver equipment to the country is covered by an insurance. So the cost is covered by an insurance, but you are faced with the problem of the time now. So this may be qualified as a force majeure or an exceptional event, because if you read subclause 18.1 in 2017 and 18.2, it satisfies the requirements, the 4 requirements of the force majeure or exceptional event. There's no time to explain all of these. And 18.2 in 2017 or 19.2, 1999 suite, there is an element of impossibility. It is impossible through no fault of myself as a contractor to deliver the equipment on time. The ship sank. Okay, the cost will be compensated by the insurance company, but the delay, it's going to be impossible to be compensated. Maybe if the employer, but this is highly unlikely, will apply delay damages on the contractor, this might be also part of the damages to be claimed from the insurance company, but rare it is the case. This is considered consequential damage. The insurance company will compensate you for the value of the equipment being shipped, not the other consequential damages. But if this is the case and you deal with this correctly from a contractual point of view, it is most likely, with regards to time, a force majeure event or exceptional event and cost from the insurance company. I saw one of our colleagues raising their hands online, but maybe they lowered their hand.
You already answered the question. It's the same.
Okay. Thank you. So any question from our colleagues online?
Okay, Husni, I think I'm looking at the time.
Yeah.
And I think we promised we would not keep you too long so that you could have some rest. But I think that was really very, very good and useful. Thank you so much indeed. I'm going to ask that our secretariat make sure that the recording is made available because there's quite a lot packed in there. And I want to thank you. But before you go, I want to also ask my little question. We know that you've given us a bit of the history of the FIDIC books, and we can see the advantages, the great advantages. But it may be useful if you tell us in a few minutes how things are moving with the times, because we are now looking at a few other aspects. Digital, for instance, collaboration is being done digitally. We're looking at sustainability issues, environmental considerations, and these are all now compliance in these also need to find their way into the documentation. So it would just be nice to hear from you for a few minutes on what is bringing FIDIC into the real right up front cutting edge. Thank you.
Thank you, President Conley, on your question. And if I may add to the issues, AI also is a pressing issue.
Absolutely.
As a development in our current times. Now, it's very difficult for any entity to catch up with standard forms of contract because, as I have explained previously, it takes years to publish a standard form of contract, particularly at FIDIC, because we hold quality sacrosanct. But for example, with regards to sustainability and carbon management, we have just released in the first week of December FIDIC CEM Carbon Emissions Management Guides. It addresses the issue of carbon management, how we embed our red book and white book forms of contract and other guidances for other forms will follow later on, how we can embed stipulations on contractors to reduce the carbon emissions. So this is one good example because we followed, the UN declaration and so on and so forth to reduce the carbon emissions. So one of the most recent developments that we have just published, and we will continue publishing for the other forms of contract, is the CEM guide, Carbon Emissions Management, now for the time being for the red book and the white book. We have been contemplating and working on a collaborative form of contract. It is, hopefully, it is planned to be published this year. As I said previously, we looked into PPP, but we will end up with a guideline. Currently, at Task Group 15B, as a chair of Task Group 15B, we're working on the golden principles for the services agreements. The golden principles issued in 2019 are on the works contracts because it gained a lot of positive feedback. Professionals started demanding we want golden principles for the consultancy forms of agreement. Now, also, we've been thinking, but we find it very difficult to adopt, which is AI and, electronic forms of contract. This is not something easy to adopt quickly because, as you can see, AI is developing by the day. I'm a member of the ICC, International Chamber of Commerce, International Center for ADR, and the ICC Commission, and I'm on the ICC Commission's task group or task force on AI. And it is really difficult to write anything these days about AI because things are changing rapidly by the day, not by the week, not by the month, not by the day. Every day, I'm very interested in AI, and I consider someone who is, as a civil engineer, I have good knowledge about AI and also from my legal background. And I find it very, very difficult to keep up with the changes. It's really crazy on every single front. But at FIDIC, we are trying. For example, in the 2017 suite, we have included guidance on the BIM, Building Information Modeling. And it was relevantly quick because BIM became a hype, or let's say its use became widely spread in 2009, 2010. Now, to publish a guideline in 2017 is something really excellent by FIDIC, and it was updated later on in the reprint 2022. So we are trying, we are hoping that we keep up, but in this day and age, developments are really fast, crazy fast. So we are trying to catch up. And also, we don't want to end up in a situation that we issue something that is out of date and no longer relevant. It's a difficult balance, but we are trying our best at the Contracts Committee.
Thank you very much. I think that's very reassuring. And I think what most of our members here need to do is to also spread the gospel to make sure that, we're actually keeping right up with the times. And we need to be thinking internationally, just as we think locally, but definitely internationally. Thank you very much indeed. I'm not sure if there's actually any moderator for this session apart from yourself. So if the MD is not online, I will probably just thank you very much for this session. It is interesting to say that we don't need you to have to fly into Abuja to do something like this. So I'm going to please request that we do keep in touch, and we'll be having
Absolutely.
From time to time, we can have a few of these type of, sessions to rub minds together and get to know ourselves better. So thank you very much indeed. And to the attendees, I want to say thank you very much. I should let you into a secret that just about 2 or 3 hours ago, I was speaking with Husni, and he did say that he wanted to be encouraged by having enough people to talk to and not 5 or 6. So I hope we've all been able to do that now. And I think at the height of it, there was actually well over 40 people. And I should tell you that there are actually a lot of engineers and other professionals who would love to have been here, but we tried to limit it initially to just ACEN members, and then we opened up to a few others. So I can assure you, if it had been wide open, you'd have got well over the 100 mark. But thank you very much again, and as you go back, we pray that you have a safe journey back home. Thank you very much indeed, and look forward to seeing you very soon. Thank you.
Thank you, Engineer Conley, President Conley. Thank you so much for your kind words and for this kind invitation again, and for offering me the opportunity to speak and to my colleagues and friends in Nigeria and learn from their experiences. So thank you so much. Looking forward for similar master classes online. As you said, I can do it from my home, and I'm available and willing to help in any way I can. So thank you so much. Thank you for your kind words. And thanks to the attendees, online attendees, and the in-person attendees here in Abuja. So thank you, everyone. Thank you so much. Thank you.